Welcome to Germs Justice, a 3-part Facebook Live event presented by John Fain, where you get to ask legal and ethics experts your questions about the pandemic and its impacts. Brought to you by the University of Melbourne Law School, Big Ideas on ABC RN and ABC Radio Melbourne.
Germs Justice Part 3. Today we look at the rules and regulations and governance that has arisen in a state of emergency. How can you have a state of emergency that justifies doing things like banning protests, which was tried by the New South Wales Police just the other day, or, for instance, shutting borders, which is still contentious? And how can some of those measures, and in particular the creation of something called a national cabinet, how can those measures outlast the emergency, as indeed is planned? The national cabinet, it's expected, will go on permanently, even though it's justified by a pandemic and an emergency. These are interesting questions that we're tossing around today with 3 experts from the University of Melbourne Law School. Professor Adrienne Stone is Director of the Centre for Comparative Constitutional Studies. Dr. Tom Daly is Assistant Director of the Melbourne School of Government. And Associate Professor William Partlett is a Public Law Specialist at the Melbourne Law School. And they all join me, and I'm looking forward to your questions, which you can send in now on Facebook Live. Are you concerned about the grab for power that seems to be in some way just inevitably accompanying a state of emergency? There are some serious issues of human rights, of regulation and accountability here. Let's start with Adrienne Stone. And thank you very much for lending us your expertise today, Adrienne. How can we have a national cabinet that's just been kind of pulled out of thin air and given who knows what powers that's justified by a state of emergency? What's the law about creating something called a national cabinet?
Well, I don't think there's any doubt that there's a constitutional basis for the national cabinet as long as it's done appropriately. I mean, the way to conceive, I think some of the problem and confusion around this is the description of it as a cabinet. It's clearly not a cabinet. It's clearly something like a Council of Australian Governments, and we've always had that. I mean, we've had the Council of Australian Governments, COAG, which this will now replace. And the National Cabinet has the same kind of footing as that. So long as it's conceived of properly, there's no constitutional problem with its basis. But...
Oh, there's a big but coming.
There's a but coming, yes. And this is the following. The suggestion seems to have been made that this is properly conceived of as a subcommittee of the National Cabinet.
The federal government cabinet.
Of the federal cabinet, as a subcommittee of the federal cabinet. And I think that's just got to be abandoned. It is absolutely wrong in conceptual and constitutional terms to think of this body being part of the federal cabinet. The basis on which the premiers and the Prime Minister meet is each of them hold executive power as the leaders of their own governments.
And that's established by the Constitution.
That's established by the constitutions of the states and the Commonwealth. Yeah. And they are each then responsible in turn back to their own parliaments. So I think what we need to understand is that this is a Council of Australian Governments by another name. It's going to operate differently and maybe better than the old one. It is not a subcommittee and should not be conceived of as a subcommittee of the National Cabinet, and therefore we need to understand more about its operations. On what basis do decisions made on it? On what basis do we know what goes through to them?
Yep.
Well, they have to take everything back, in my view, to their cabinets and be held accountable to their parliaments through their own cabinets.
You can't just get a bunch of people, put them in a room and say, we're going to call you a cabinet, and then have all the secrecy and authority that comes. You can't just pluck that out of thin air. Surely that's not allowed.
That's right. You can't. You can. The Australian governments can cooperate, no question. If they want to cooperate through this body, they can do it. But in my view, they cannot claim legally, therefore, the secrecy that attaches to the federal cabinet just by calling this a subcommittee of the federal cabinet. That seems to me to be wrong.
Is there a sleight of hand here then? Because cabinet documents, for instance, you can't FOI them. You can't ever see them or get access to them for, 30 years or something. So if they're calling this a national cabinet, is it an attempt to basically expand the reach of that confidentiality and secrecy?
Well, I think we have to be watchful of that. Now, there certainly was this idea earlier on that it was a subcommittee of the National Cabinet, and that would have those troubling consequences that you just mentioned. But I think it's very important, and it's possible that that idea will just fall away and that this will become regularised, right? Now, and this is the way in general we need to go forward. We've had a state of emergency. We've had some innovation done under circumstances of emergency. Mm-hmm. Maybe you're not going to get everything perfectly right in those circumstances. But
you might make a $60 billion mistake.
Right, for instance.
You might get your costings a bit wrong.
Just to pick a number out of the air. As we go forward, we need to properly understand what this body is. It is a council for the cooperation of Australian governments, and it cannot either attach itself to the federal cabinet, nor can it allow the premiers and the prime minister to detach themselves from the ordinary process of accountability through their own parliaments. So we need to know, how do we decide what matters go before the national cabinet? What are the basis of their decisions? What's happening? Are the premiers taking them back to their own cabinets? All of that needs to come out, and now's the time to start insisting on it.
Indeed, because it's about holding power to account,
That's
which
right.
is what our Constitution is all about, and avoiding the chaos we've seen that we're going to talk about in some other countries. And I'll come to William and Tom in just a second. But the second issue that's exercising a lot of minds, including soon the High Court, how can you shut borders in Australia? How is that allowed? We have all sorts of provisions in the Constitution saying you're not allowed to interfere with free trade between the states, and yet this has passed almost unremarked upon. And Mark has been quick on the questions on Facebook Live, and you can add yours in as well. Just go to the comments or questions section and you can send them in, and we'll work them into our conversation right now. Mark writes, why are interstate borders still closed? To which I preface it by saying, where's the power come to close borders in the first place? Okay,
so there's kind of two separate questions. Where does the power come to close borders in the first place? Well, I think it's generally accepted that the states have the power to do that, subject to anything in the Commonwealth Constitution. And you rightly point out that there are some provisions in the Constitution that make this problematic. There is a requirement for free trade across state borders. There's also a requirement for free movement across state borders. And there's also a requirement, because remember, these border closures have exceptions for residents. There's also a requirement of non-discrimination on the grounds of residency as between the states. However, all of those provisions are recognised to have exceptions where the states might, in unusual cases, protect their legitimate interests. Now, I think it's never been tested, because we've never been in a circumstance like this before, but that at the height of the pandemic, it probably comes within those exceptions for the states to put at least restrictions, if not complete border closures. And that's how they, as I understand it, they work. They were restrictions subject to exceptions. The question, therefore, for me as a constitutional lawyer is not whether they could do it in the first place, but at what point does it become impermissible? Now, any restrictions put on travel across state borders have got to be proportionate to some kind of legitimate interest.
So there have been cases before the High Court on this sort of stuff that we can look to for guidance?
So, yes, there have been, but nothing that really resembles the depth and of the restrictions put on. But let me give you an example. And I know for the law students back there, I'm going to give you some hopefully welcome but maybe troubling flashbacks to your constitutional law cases. But, I mean, there's a very well-known case in which the High Court upheld a restriction on interstate trade, which essentially allowed Tasmania to protect its crayfish population from overfishing, and taking the view that, you know, what was going on here wasn't actually Tasmania trying to give its own crayfish industry a competitive advantage. That would be impermissible, but it actually had a legitimate environmental reason to be protecting its interests.
To stop overfishing.
That's right. And so it's by analogy to that kind of case that you might be able to say, look, there are circumstances where states have very legitimate interests that they're entitled to protect. But those restrictions need to be proportionate, and as every day goes by with low infections, I think the case for these border restrictions becomes weaker and weaker, and we will see what happens.
Now, William and Tom are itching to jump in, and if you've got questions that you want to toss our way, please do, and we will work them in through the conversation on Facebook Live here on Germs and Justice number 3. Looking forward to your questions as well. So, William, let's just keep this discussion going about authority and power. One of the issues here, guaranteed sooner or later, someone is going to have their business adversely affected by a decision of this national cabinet, as it's been called, which is kind of like just another government slogan as best as we can tell so far. And they'll challenge it. They'll say, hang on, you don't have that power. You can't just make it up. You can't just pretend to have an authority you haven't got. What's likely to play out here? How do you see it happening?
Well, I mean, it will depend on the nature of the decision coming out of National Cabinet. I mean, again, I want to repeat very much what Adrienne was saying. I mean, the National Cabinet is not itself a cabinet. It itself does not have authority to make decisions. The decisions are, in theory, at least, being decided on in an environment, and then actually the legal authority to make certain decisions is made by either the Commonwealth government or by the states, respective to their own constitutional systems. So it would be judged the extent to which that decision made by National Cabinet, if it was a decision that was implemented through legislation at the Victorian level, then of course it would be challenged under the Victorian Charter or the constitutional system in Victoria. It's subject to the constraints that the Commonwealth Constitution places on it.
Okay, but this is all the states. So effectively, are you saying that for a decision of this so-called, in inverted commas, National Cabinet, for it to be binding, every single state and territory would need to redo the decision in order for it to have any authority, in which case that's a very clumsy and contrived way of going about running a nation.
We've seen that already with schools. So we've seen the decision made at National Cabinet that schools would reopen, and individual states went very different not different directions, but they certainly went at different paces with respect to when schools reopened. Victoria was one of the last to reopen. Just a couple of weeks ago, and I think on Tuesday the entire schools are coming back. But Victoria has been significantly slower than New South Wales. So the extent to which
no one rushed off to the High Court over that. But when it comes to possibly millions or even billions of dollars worth of trade in something that gets held up by this process, I would have thought you can go London to a brick. Someone's going to go to the High Court and say, "Hang on, they can't do this to me and my business." It's all going to get challenged.
If it's a trade-related discussion, if it actually does, then it goes back to, again, I was just talking about the idea of proportionality, which is a broader idea, and the extent to which it's if we see the legitimate state interest in this decision dropping, right? If we see the pandemic really being under control, we move towards full eradication, then I think, it really gets less like there's a legitimate state interest, and this looks more and more like protectionism.
And given the complications of every single state, parliament and territory needing to get this precisely right, the chance for some careful litigator to unpick the arrangement is pretty good at some stage. They'll find a flaw in what people have done, as so often lawyers do. Would you expect that to happen?
Potentially. I mean, I think Adrienne wants to come in on this.
So what I was going to say is it's just important to keep in mind that no decision of the National Cabinet gets its legal force by virtue of this fact that it is a decision of the National Cabinet. It gets its legal force by the fact that it's either a decision within the executive power of a state or the Commonwealth, or it gets enacted through law. Now, having said that, I'd like to say something in favour of the National Cabinet, if I may. I don't think it's been clumsy and ridiculous. I think that actually what we have seen through the National Cabinet, which, to repeat, I think needs to be regularised in a certain kind of way. But we've actually seen some pretty effective state-federal cooperation in circumstances where we really needed it. And it has allowed for there to be a somewhat coordinated national approach, while at the same time allowing for very real differences between the states to be given effect. I mean, given how differently the pandemic has played out in Western Australia from New South Wales, it wasn't appropriate to have the same regulations. And this National Cabinet has allowed there to be coordination, but at the same time for diversity. I actually think that it was our federation functioning pretty well.
Okay, now, Tom Daly, what about international travel? Because there's not just a ban on travel between some states and the like, but there's a ban on international travel. What would happen if someone challenged the decision and said, you don't have the power to stop me doing something like getting on a plane and going where I want to go to?
Well, it's a really difficult one because, I mean, the international travel by definition is going to be involving more of the states than Australia. And while, of course, you can sort of set certain limits as to who can and cannot come into your own country, there are going to be issues about, whether your own citizens are in other states, for example, or, as we've been discussing, for universities and so on that need certain types of citizens from other states to come in to continue functioning as they have been. Those are going to be big questions.
Okay, so let's just draw that through. And Miranda and Elisa have both sent in questions along these lines. Elisa says, does it apply to international borders constitutionally the same way? And Miranda saying, how's it legal to confine citizens within their country? You're suggesting, well, maybe one of the universities that wants to bring, 1,000 students in from India or China might go to court to say you can't stop us from trading with our students who want to come to the country. You can't make up rules. If they comply with quarantine and all the rest, you can't stop them arriving. That's a reasonable proposition, isn't it?
I mean, I suppose it is, but I suppose our starting point is that the restrictions placed on travel in the first place are emergency measures. They're temporary and they're subject to review. And so that review should sort of involve the potential to ease, as we have seen, and as we've seen happen, from last Monday onwards, especially there should be potential for easing of these restrictions, but I think travel is going to be one of the most difficult ones to ease because you're dealing with a whole range of states and a whole range of outcomes in terms of pandemic response.
I'm going to be more than mischievous here. Given that you all work for a university that has publicly, along with many other universities, said it's costing them hundreds of millions of dollars in lost revenue, surely the combined constitutional brains of one of our or all of our law schools could put together a challenge and say to the government, you can't kill the universities by unreasonably refusing permission for students to come into the country, do their 2 or even 3 weeks quarantine, whatever safeguards you want to build in. You can't stop us. It's not legal. You don't have the power. Gillian's written in the nubbies, where does the power come from to not reopen as the situation moves to the next phase? William?
Well, I just want to say on these issues, the media does report a lot of these as travel bans, and particularly between the states and Australia and then also internationally. But of course, there are reasons that people can travel. Australians can leave Australia if they have for compassionate reasons and so forth. Australian citizens are still travelling back into Australia, and I think at least the constitutional analysis here, which is a broader one, is to say there's 2 competing interests at play here. One, as you're pointing out, is a very strong economic interest that Australia, not just the universities, but the entire Australian community enjoys with globalization and trade between the states, and also between Australia and the international sector. So that's a very important interest. But there's another interest, of course, here, which is the safety of the Australian community, and those need to be balanced.
But it can be safeguarded. Just last week, the High Court made a decision about a cattle ban of cattle's being exported to Indonesia back in the days of the Gillard government. Said no, there was no power. It was done illegally, and it cost various exporters huge amounts of money. This is directly analogous. How can a government make a decision as the initial rush of the emergency passes? How can they maintain a refusal to let people start to move again? Now we know what safeguards apply. We know how to apply them. We know they work. How can they legally justify continuing with something that's so difficult to justify?
So in relation to the interstate restrictions, the principle will be proportionality, because there's this provision in Section 92 of the Constitution that is subject to this proportionality exception. So you're right, there can be a challenge, and then I hate to be a lawyer about this, but it's going to come down to a careful assessment of the details in the context of the particular case at the time in which it happens. So you'd need to look not just at the fact that there is a, quote, travel ban, but what exactly does it prevent? On what basis can you get restrictions? How? And you'd need to also look at the state of the pandemic. Now, in relation to travel from outside of the country into the country, there is a clear power that the Australian government has by virtue of it being the government of the nation to determine the basis on which entry to Australia is affected.
But what's the rationale? I'm not getting into the weeds of the medical advice here, but if you know that 2 weeks quarantine solves the medical problem, what's the rationale for refusing permission for people who are agreeable to a 2-week quarantine and letting them in?
Just a boring legal point for a moment. Because of it being a power of the Commonwealth Government rather than a restriction on the states, the standard will not be something like proportionality. The standard will be something a little bit lower to show that there's at least sort of a rational basis on which the law could be made. Okay, now, so I think it'll be a little bit harder just legally to show that the restrictions on travel in and out of the country are sort of beyond the pale or unreasonable, but I still think it can be done. And you make the very good point that if you can show that there's a less restrictive alternative way of achieving the same end, then that I think ought to have very considerable weight. I mean, you could bet your bottom dollar that goes to the High Court and the government lawyers up there saying there's a reason why that's not good enough. We'd have to just see how that all played out. But that's the way the conversation would go.
Let me for a moment be the whatever it's called, the combined meeting of vice-chancellors, and I consult the 3 constitutional law experts in here with me now and ask each of you, we are losing hundreds of millions of dollars and thousands of jobs because of this ban. We're not sure of its legal foundation. Should we challenge it? Tom, do you think we should go to the High Court and challenge?
That's a difficult one, but I suppose if you're trying to weigh the risks to yourself versus the low risk if you're still maintaining quarantine, for example, the advice may well be, yes, this is worth taking a chance on.
I'll come back to Adrienne, but William?
I actually would disagree on this. Yeah. I think the answer is no. My view would be no. I don't think that there is a particularly strong legal challenge here. This is an area where political kind of political constitutionalism's got to play out, and the pressure on leaders from business, not just the vice chancellor, as I said, but others, should play out and push them to make the right decision in Parliament, as opposed to I don't think the High Court would be particularly helpful in this context with respect to international travel of non-Australian citizens.
Okay, Adrienne, because I often, and on the political solutions, sometimes litigation is just one of the levers involved in a political tussle. But would you recommend it or not, Adrienne?
Only as a last resort if you couldn't get a much better political solution, because I have to say, I think that the state's challenges to the internal restrictions are more likely to succeed than any challenge to the external restrictions. And the external restrictions are going to be much more problematic in relation to citizens leaving than to non-citizens coming in.
Okay, I want to look at other countries as well, but the questions are continuing to come in on this. Carolyn says, I'm in Wyndham City in Victoria, but I can't see my daughter in Townsville due to restrictions put in place by the Queensland government. And they say because of the clusters in Victoria, Victorians aren't allowed. So we're classed as a hot zone. So where does the power for that definition, and what are the limits on these sorts of powers, and where's the authority yet again? We're asking, as Carolyn is asking, for some of these decisions that no one's even daring challenge. So we'll see whether that moves on as the pandemic, as the light at the end of the tunnel starts to emerge. We'll see where that goes. But I want to quickly, before we kind of get really I don't mind getting stuck into the detail of this, but there's so much more to talk about as well. Now, Tom, overseas, both you and William look at a lot at what's going on in other countries as well. Take us through. Other countries are grappling with exactly the same pandemic challenges. We're seeing, it seems almost the pendulum's flicking across to authoritarianism in so many countries. It's like governments are grabbing power while they have the chance.
So I think the best thing to think about this is we have over half of the world's states are under state of emergency. By about mid-April, about 98 states had already sort of declared a formal state of emergency. Then you have a whole range of states that are under emergency measures, but not under a formal state of emergency. Now, state of emergency itself, there's nothing undemocratic about it. It is completely compatible with the democratic system to say, we have a huge problem here, and we're going to have to initiate temporary measures that are subject to adequate scrutiny, that will be sort of that will not live on after the emergency itself, and that are installed only insofar as they are absolutely necessary. So, for example, in all of these states, you have governments wielding much wider powers than normal. You have parliaments and media, which are normally sort of key areas of scrutiny, pretty hobbled in many cases. And you have, clear rights like the freedom to assemble, the freedom to practice one's religion, rights to privacy and so on, have all been affected by the measures being taken. And you have, in a lot of cases, the government actually derogating, so partially pulling back from their commitments under international human rights treaties in order to achieve a certain level of transparency in what they're doing as well. But what's really important here is the temporary nature and that it's subject to enough scrutiny and review.
And if you want to, if we look across the board, a broad spectrum, if we want to try and draw some big picture conclusions so far, there's a centralisation of power like we've never seen in the modern era. It's almost as if conventions, regulations, procedures that have taken decades to evolve, usually to do with stemming abuses of power, have just been thrown out the window with barely a thought. In so many countries, you can look at what's happening in Europe, the United States. I can't even get my head around what's going on there at the moment. It's extraordinary. I'm sure William will have something to say in a second. But just you look at what's happening in Hungary, in Turkey, in the Philippines, in Japan, in so many countries. They're just clamping down on freedom.
Absolutely. So in a recent policy brief we produced, we sort of divided countries across the world, or democracies, into 4 categories. One was effective rationalists, the sort of New Zealands and Australias and Irelands, who took an approach of temporary measures, adequate review, and clearly trying to make sure that they maintain as much of the democratic system functioning as possible. Then you've constrained rationalists, those who have taken a fairly fact-based, rational approach as well, but who are much less able in terms of their state capacity to roll out certain measures like lockdown that's going to be effective. So South Africa and India would fall into that camp. Then you have what we call the autocratic opportunists, the likes of Hungary, the likes of the Philippines, who have pounced on the pandemic and installed new laws, new legal measures to trammel freedoms, to sort of trammel existing institutions like parliaments, and where, as in Hungary, there's no time limit. It's permanent, possibly. And then finally, we have the fantasists. This was the final category, which was the likes of Brazil and the US, where the top government, both federal systems, have simply refused to accept the reality of the pandemic as the health emergency that it is. And that has created chaos in terms of governance and chaos legally.
Fantasists, I love that. William, the bottom line is, does democracy survive the pandemic?
Well, that's a really difficult question to answer, and
that's why I put it to you.
I think the key point that Tom makes, which I 100% agree with, is these emergency measures. We know in times of emergencies, even democracies have to limit rights. All right? Rights are not absolute. So they have to be limited. We think during times of war, we limit the rights to freedom of speech with respect to troop movements and to respect to what's happening on the front and so forth. During times of pandemic, we limit movement in many cases of citizens, and these, or we might even limit other types of things. Now, these things have to be temporary. So I think the picture's still. I guess really the jury's still out on that. What I do want to say, though, is another interesting perspective looking overseas is to see how authoritarian regimes. So a lot of what Tom talks about is the effect of this on democracies, and we see this very much. But I think there's a flip side to this, which is very interesting to think through. Well, how are authoritarian regimes dealing with the pandemic? Now, we see a lot of propaganda coming out of places like China saying, look, the authoritarian model is actually more effective. And I think there's actually some pretty strong evidence to suggest that's not true. And this comes from a part of the world that I study quite closely. This is the Russian Federation, the largest country in the world. And in many cases, we see a lot of the problems of authoritarian centralized structures of government, particularly personalized governance, we very know the Vladimir Putin himself, the one who rides bears and uses this to he has not been able to take this strongman approach particularly effectively to the pandemic. In fact, Russia's badly bungled this, and it's exposing already existing problems in a highly centralized, personalized system, which we can see a little bit more because Russia's a little bit more open than a place like China, where it's much harder to see what's going on, and particularly how things are going on. So I think that's an interesting example as well to suggest that authoritarian is not the answer to this. So democracies, as they think through, and going back to your question again, democracies as they think through should snap back to the normal once this is over, because that's actually the best form of actual effective governance.
So I've got Lots and lots of questions, and I will get to them, Jenny, Carolyn, Daniel, Michael and Therese, in just a second. And if you've got a question, do send it in as well, and we will get to talking about protests and banning protests, as we've just seen in a moment as well. But I did foreshadow we'd talk about the United States, and we can't avoid, look, there's an elephant in the corner of the room. The most litigious democracy we've ever seen, and yet I'm not aware, has there been any attempt to challenge the emergency powers or some of the issues and the delicate balance between maintaining social distancing but the Black Lives Matter protests over in the States? Has that been before the courts in a hurry?
So there have been actually a lot of litigation, largely in the state courts. In the United States, because in the U.S., obviously there's been a lot of noise coming out of the White House and so forth. But in the United States system, the federal system, ultimate decisions for matters of public safety and of movement in many cases are made at the state and local level, not at the federal level. And in fact, we saw a recent Twitter battle between Trump saying he was going to order the governors to do something. The governor said, no, you don't have the authority to do that. And ultimately, he backed down. And this was with respect to stuff happening in New York. So where we have seen the action is individuals bringing cases to state court systems and state Supreme Courts. So the state, I think it was in Wisconsin, the state Supreme Court struck down some of the stay-at-home orders as being a violation of the actual state constitution. So we've seen. So a lot of this has been really the importance, again, which we've talked a little bit about in the Australian context as well, but of how much the federal aspects of constitutional governance come out during a pandemic, which is really interesting. We think, this is all about the center making decisions, but in particular in the United States, particularly as Trump, as a fantasist, as Tom calls him, has really not been able to respond or coordinate. Everything's fallen onto the states. The states, state governors have had to make decisions, and in many cases, even local mayors or heads of county councils have been making the decisions about what the specific rules are, and those are being then challenged in the state system.
And whether they're well equipped and the like to do so is another question. To protests in a second, but some quick contributions that have come in. Michael says the National Cabinet slogan or tag that's been addressed, it's all about cabinet confidentiality. And a politician I spoke to just recently said, no, it's actually about sidelining the bureaucrats, because the old system had been captured by the bureaucrats. So this is a hitting the reset button where the politicians are coming up with something that pushes the bureaucrats aside, which I thought was really interesting from an insider. Daniel's written in, do you think the continued state of emergency in, for instance, Victoria is there because the government can put back a tight lockdown if there's a second wave, which is an interesting and plausible explanation. Carolyn's written, this is now an endemic. C-19 will be here for a long time to come. It's not just a pandemic. So we don't live yet, and we may never, in a post-COVID era, she says. We will live with it for the rest of our lives. And she says, I'm a nurse, I work in the public arena. So unless and until a vaccine is produced and rolled out, this is not a temporary thing. Factor that in, which is truly chilling. And Jenny says, people need to behave differently and maintain the 1.5 metre distance. I don't see this happening to any great extent in your daily life. Look around you now. And states, including countries, won't take the risk of reopening borders. To do so would be not looking after their citizens. Let's get to the protests. We've seen huge numbers of people turn out on the streets despite, at various stages, police, politicians and even courts at one stage in New South Wales saying, no, this is not allowed. So, Adrienne, what we've got now is the New South Wales Court of Appeal overruled a judge who said, no, I'm going to give an injunction to try and stop people going out on the street. You couldn't see a sharper example, could you, of the clash of values in this particular era that we're seeing now?
It's an extraordinary sight. So let me say that I just think that the interests on both sides of this equation are just so very important and strong, because protest is so important in a democracy. And then if you look at what these protests are about, they involve allegations of the most serious kind of government misconduct against a very oppressed population who rightly, in my view, understand that this is the moment, that after decades, 200 years of problems of this kind being ignored, that this is the moment. And on the other hand, you have a pandemic which has had the most extraordinary effect on every single Australian. So I just feel I ought to say I just have never felt like judging would have been a harder job than it was for the judge of the New South Wales Supreme Court, who on a Friday night had to make a quick decision about this. Now, it's true that the Court of Appeal did come in and make another decision, and that's what they're there for, and the system seems to have worked in that respect. But I think, we need to really understand that on both sides of this equation there are really difficult questions. Protest The importance of protest just simply can't be ignored forever. And so we need to find some way to square this with a post-COVID, a post-lockdown world.
This is Germs Justice number 3, brought to you by the University of Melbourne, the Melbourne Law School, Radio National's Big Ideas, and on Facebook Live in the ABC Radio Melbourne studios. If you've got a question for our 3 constitutional law experts, we've got just enough time for you to send it in, and we'll try and deal with it between now and when we do run out of time. And I'm looking forward to more contributions. They've been outstanding so far. But what this is really about, and it's a recurring theme from Germs and Justice 1 and 2, and number 1 was about the app and technology and privacy, and number 2 was about the industrial relations reform. And the same theme is emerging now here as we talk about governance and rules. Protections for the citizens, protections of our liberty, protections of our democracy that have taken generations to evolve have just been tossed out on each of those 3 issues, on the privacy issue, on industrial reform, and now on governance. Suddenly, it's almost as if government has panicked and said, you know what? None of that counts. This is what we have to do, and we have to do it right now, and no one will get in our way as we do it. Is that an exaggeration or a fair assessment of what's going on? Adrienne,
can I say,
first?
I think it is an exaggeration to say they've just been tossed out. Now, and also, let's say, the government in the form of the premiers and the Prime Minister and is only part of the equation. We live in a democracy and there are accountability mechanisms. And this isn't a fashionable point of view, but in relation to freedom of expression, we have better legal protections than we do in relation to most of our rights. So that there is both in Victoria a Charter of Rights and there is a constitutional guarantee of freedom of political communication, both of which are going to come into play. Now, so if this kind of conflict over protests continue, I think you will see there will be quite sharp interventions legally.
Okay. Tom, am I exaggerating when I put the proposition that way?
I think it is an exaggeration in the sense that I do see governments across Australia have been careful about the measures that they've put in place. And let's keep in mind that internally, the emergency measures are reviewed very regularly. I mean, daily. In fact, in terms of what is being done. I think it's important but also to learn from experience elsewhere where we can. So, for example, in South Africa, they put in place a COVID-19 designated judge to oversee the government's use of phone data for contact tracing, for example. So this is
for the app.
For the app, a former judge of the Constitutional Court is now in place doing that job. Scholars here have suggested that there could be a COVID-safe committee that does a similar job. And so, there are lessons that can be learned from elsewhere. In terms of protests, sometimes it's a numbers issue.
But back to my scenario of panic, the Australian Parliament was not going to sit for months. In fact, that decision was revisited, and thankfully there's been a meeting of Parliament, and there will be more. But the first announcement was, OK, we'll just give up on Parliament. Who needs it now?
And that was a huge difference to the likes of the UK or Canada, for example, where you had a move to fully online or hybrid parliaments over time, and where there's face-to-face and online. And even, the parliamentary organ that provides some research assistance to the federal parliament here provided information on those measures taken shortly after the recess here. So the information was there available.
William?
Yeah, I mean, I agree. I think the way you put it was an exaggeration, but I do think there are threats here. I mean, we can look at even to Australian history. and particularly the Federation. World War II, obviously probably the most recent major emergency that Australia's faced, saw a significant change to the way the Federation was set up. And this is particularly with respect to the fiscal balance between the states and the Commonwealth. Prior to World War II, of course, the Australian states actually had income taxes, and they lost that. They were forcibly stripped of that by the Commonwealth during World War II and never got it back. And this has led to a lot of the ways in which the Federation is now run, and a lot of the problems of Federation and how Federation is run, and in particularly the view of the Commonwealth. Well, the Commonwealth raises all the money, so we can tell the states what to do with tied grants, with the spending power. So I do think we need to, and I think I 100% agree with Tom. I think there needs to be, even though we might in times of emergency take away some accountability mechanisms for obviously safety reasons, we need to maintain a very close view on what's happening. And I think the National Cabinet might be just one example of this. But there need to be accountability mechanisms maybe through the media, through discussions online, through all these, when we're seeing this, protests online and so forth. But even, socially distanced protests that we saw in Melbourne just on Saturday, where people are saying, look, we want to say something to the government. We want to make a point, and we want to hold people accountable and hold the government accountable for certain things, because we don't want something to change in the emergency and then stay that way.
Yeah. But the government was telling people, the police were telling people, the health and chief medical officers were telling people in state after state, don't do it. Yeah. People did it anyway, and they're nationally hundreds of thousands.
And as they should have. And I think there's a very important aspect to making that statement, I think. In terms of saying, look, we do need accountability mechanisms, and if one of them is being at least careful, wearing masks and being social distanced, but then going out and actually protesting is, I think, is an important aspect. We don't want to break things now that can't be fixed.
So if someone gets a penalty, I think it's $1,600 for breaching the social distancing rules arising from the protests on the Black Lives Matter marches, you'd recommend them challenging it in court by the sound of it.
I think so. Yes, I think as I understand it, the organizers of the Black Lives Matters protests here in Melbourne have been fined $1,600. And I would absolutely suggest that they challenge that fine. At the extent to which they took precautionary measures, they asked the individuals involved in the protest to wear masks or to engage in social distancing. Leave it to the court to decide, but I do think that's something. This is an important value that we don't necessarily give up, particularly given we're no longer at the height of the pandemic now, right? The facts and the circumstances are important, I think.
So the full court of 3 University of Melbourne Law School constitutional experts is that I exaggerate. This is the unanimous opinion of the 3 of you, for which I therefore have to apologise and plead guilty. But it was a way of, it's like the cartoonist, you inflate everything in order to test it and then rebuild it when you've had the balloon basically pricked. I suspect that the court challenges will come thick and fast as we get to the economic recovery phase, and certain things are ruled in and ruled out. And we'll see strong and vested interests and people with deep pockets having their particular industries or activities allowed or not allowed and disallowed, in which case there will be a fair bit of sharpening of elbows, and we'll see what happens there. Lots more questions. Miranda says, you can't say countries won't take the risk of reopening borders. Look at Italy, one of the worst hit places in the world, and they still kept their borders open. And in fact, the UK was very late to introduce quarantining. They didn't actually shut the border. They just introduced quarantining, but way after everybody else did. It was extraordinary. Teresa's written, I feel like the, in inverted commas, National Cabinet was something that was needed at the time. It was something that had to be done quickly. Decisions needed to be made quickly. It wasn't that COVID wasn't going to wait for us. But we should be proud of the way our leaders helped us through this, especially compared to other countries. But, capital letters, they now need to be careful they don't take the decisions too far. People will and are starting to question the decisions made. And I think that's precisely right, Therese. Spot on.
Could I just say something in relation to that? I agree with Teresa's sentiment. And I want to say that, yes, there's in lots of ways I've been sort of reassured by the way Australian government has functioned. I've also been pretty reassured by the way the Australian people have reacted through this, because they've both been at once, pretty cooperative in the crisis. But then as the crisis has begun to lift, I think what we saw on the weekend was a great reassertion of citizens' civic rights. And I think that that's something that actually we just need to make sure that people continue to do. Be cooperative, be watchful, but when you think you've got something really important, just as it always is in a democracy, keep pushing on government. And that's the kind of dance that we're in at the moment.
Tom?
Absolutely. I would just want to say I absolutely agree with Adrienne on that. And we have to remind ourselves democracy is not suspended. We have to sort of stay compliant with social distancing. We have to stay alert. We have to stay careful. But democracy is not suspended. And many different countries have shown that protest, for example, can be done and can be done in imaginative ways. But the numbers can make it difficult if you get to huge numbers like the weekend. We've had protests in Tel Aviv, for example, that were very interesting geometric patterns to maintain the social distancing. But that was only 2,000 people. Whereas we had tens of thousands at the weekend. But it's an ongoing conversation, and I think always we have to make sure that the freedom, the restrictions on our freedom are only to the extent necessary.
Not too late for your questions before we finish up on our Germs and Justice discussion number 3 today, looking at governance issues in the Constitution. And if you've got a question for my panel, Professor Adrienne Stone, Dr. Tom Daly, and Associate Professor William Partlett, all from the Melbourne Law School. If you've got a question, we've just got time for you to send it in and get some answers between now and when we finish up. So there are going to be really interesting issues that are going to get tested inevitably as we go through what I think I'll call it a hybrid economy. So we're likely to go, it won't be like it was before, but it won't be like what we've just been through either. It'll be something in between. And again, if the governments, state and federal, and maybe even local government, if they don't get the balance right, then not only is there a legal impact, but there's a constitutional, there's a freedom dividend as well. I'm intrigued, though. We are one of the very few democracies in the world that's never had a Bill of Rights or a Charter of Rights. Now, I don't know, some people roll their eyes and go, who cares anyway? We're functioning pretty well without it. And other people are just as impassioned the other way, saying, for goodness sake, can we just do what everyone else has done and accept the need for something written down that sets on paper forever what we are and aren't allowed to expect our governments to do or to leave us alone to do? Do you think, and this is a bit of a kind of blue sky question, but do you think, William, that the experience of COVID-19 and the pandemic, do you think that advances or delays the debate about a Bill of Rights in Australia?
Well, I'll leave that to others to answer, but I do want to give some perspective on this. I mean, one of the underlying kind of deeper kind of impulses underlying the lack of a Bill of Rights in the Australian Constitution is a commitment to political constitutionalism, a commitment to processes that protect rights as opposed to entrenched bills of rights that themselves are left to judges. All right, so we as Australians want to see ourselves making these decisions through parliaments, through deliberation, through discussion, and so forth. And I think in some ways, I think that the pandemic has shown, at least, and here I will again spring to the defense to some extent of how the National Cabinet's operate. The National Cabinet has actually shown a lot of deliberation and a decent amount of disagreement over schools and so forth. But that's an important part of rights deliberation that takes place outside of courts. So I think that's an important, way to think about that. So it could be the case that, circling back to your question, that we're seeing here actually some of the benefits of a political form of constitutionalism, whereby institutions and structures are put in place. But that, of course, means that we have to take special, really close attention to how these structures are set up, and particularly how the relationship between the Commonwealth and the states is itself a kind of driver of deliberation and of protecting rights in ways. And, obviously we saw how the Victorian Premier had a very different view of how when schools should reopen. And then, of course, that's a protective and important socioeconomic right to education as well as health versus others. So I think versus the Commonwealth. So I think these types of things in some ways is shown the advantages of political constitutionalism and some of the limitations. If you look at the U.S., a highly kind of judge-led Bill of Rights kind of culture, we haven't seen the courts really have kind of stayed out of it, right? This is a political. So I think in general, this shows how in a lot of these discussions, particularly in times of emergency, a lot of these become political, and we need structures critically and processes of a deliberation that are actually the way we get to final conclusions rather than the litigation itself.
Yes, lawyers usually love litigation, though. Adrienne, just before your answer on the Bill of Rights debate in Australia, Adri has written in, well, the US has a Bill of Rights. It doesn't seem to have made much difference for African Americans and other minorities. So there goes your theory that it holds governments to account. Do you think what we've been through in the last few months advances or hinders the steps that some want us to take towards having an Australian Bill of Rights?
Oh, yeah. So my view was before this, the Bill of Rights debate was going nowhere in Australia in any event. In a way, it's hard to see it delays something that was essentially not moving. I would say, and it's important to remember that when we're talking about a national Bill of Rights, there's a problem here. Because of some decisions of the High Court that I won't go into, it would not be possible to enact something like the Victorian Charter at the national level.
Victoria being the only state with a charter now.
And Queensland.
Queensland's developing one, I think. Have they got one already?
I think they have.
They have, okay.
It's very new, though.
Good. Apologies to Queensland.
So we would not be able to do that at national level. We would have to do it via constitutional amendment, which is not impossible but very difficult, and that there is another much more pressing, in my view, issue that we need to deal with by a constitutional referendum first, and this is the question of Indigenous recognition. So I actually just think practically an Australian Bill of Rights is a long way off. I want to jump on one of my favourite hobby horses and just say this, though. In relation to freedom of expression, we have something that comes awfully close, if not exactly like a general right of freedom of expression in the Constitution. A lot of people often say, it's implied, it only covers political communication. Those two features of it actually have made very little difference to its actual operation. So we have a really important statement in the Constitution. The Parliament has to be directly chosen by the people, and you can't interfere with communication that would interferes with our choices at elections, and that's something we just have to keep litigating and insisting upon. And actually, there's quite a lot of cases that have come out of the High Court, if you're interested in protest, that have upheld protesters' rights. Think about Bob Brown's win in 2016 in relation to environmental protesting in Tasmania, for example. Obviously a long time after his first win in the 80s, had another big win in 2016.
I think from memory he was arrested for protesting.
That's right.
And challenged that all the way through.
He challenged that all the way through and
all the way to the High Court.
That's right, and the High Court found that the restrictions on political protests were, because of certain ways that they operated, invalid. There's another case out of Adelaide which involved street preaching on the Rundle Mall, where the High Court was very clear that the capacity to limit the activity on the Rundle Mall was quite limited. You could stop street preachers from physically obstructing people, but you couldn't ask them to keep up. And notice that was preaching. It wasn't just, straightforwardly political communication. It was a sort of a more general discussion. So
you can, as long as you're out of people's way, you can preach to the crowd, and that's protected by the High Court, as long as you're not blocking them moving up and down the street.
Yeah. So, or just to be a little more technical about it, the Adelaide County Council is allowed to require you to get out of the way, but it can't require you to leave.
Or to shut up.
Or to shut up, that's right. So I actually think once you look at the vast swathes of our jurisprudence, it actually is a lot closer to a free speech right. It's also subject to reasonable limitations, but so are all the other free speech rights. So those three features of it that a lot of people hold up, I think, actually don't really distinguish it from what we would get out of a Bill of Rights.
And to Tom in a moment, Angie's written in, we need a Bill of Rights. We always have. I don't understand why it's such a big deal. The government clearly remains the holder of all power, not the people who they are meant to work for. Tom, other countries have grappled with exactly the same issues.
They have. And look, different courts take different approaches to emergency measures as well. Emergency measures are pretty sticky. Often in other countries like France, you've seen sorts of emergency measures taken in response to, for example, the terrorism issues in 2015 have been sort of put into permanent law. There is a doctrine, for example, a doctrine of emergency, where there is a lower standard of scrutiny applied by the courts. But I think what's most important for me is the question of, has the pandemic opened a window for us to reimagine how we do government. And that brings in issues like the political constitutionalism point. Could we think about using citizens' assemblies? Can we put more sort of, fuel into the call for a voice to Parliament, for example? It has to be a broader conversation.
Just on the emergency powers, things are being done justified by the emergency. What happens when the emergency's over, but they want to keep those structures in place? National Cabinet being the most obvious one. That's justified because there's an emergency, but it's already been announced that it's going to stay on afterwards. So do you have to rethink the foundations that are propping it up in order to make it legitimate once emergency powers are no longer relevant?
I think you need a broad-based scrutiny, but you also need an ongoing pushback to say, this is extraordinary, this is not supposed to be permanent. Because even the most democratically minded governments find emergency powers very useful. So, there is a temptation always to keep some of it.
Yeah, and bureaucrats and politicians love an opportunity. What's the old gag? Never waste a crisis. Love an opportunity to do things they've dreamt about for years but never been bold enough or cheeky enough to try. William?
Yeah, I just want to say, you're right, lawyers like litigation, but lawyers also like process, right? And constitutional lawyers are very interested in process and how constitutional design and structure actually itself carries certain values, right? So federalism is just one example we've spoken a lot about, but we see others when you have in Victoria the process of actually having to, the Parliament actually has to justify its laws under the Charter prior to passage, right? You have to have compatibility statements. So we have committees that do this, right? So there's all kinds of different structures and ways. And of course, we've talked a little about the Uluru Statement from the Heart, but the voice to Parliament itself is another form of structure, which is highly consistent with what we call political constitutionalism, but it's a legal form in the sense that it's legally enforced institutional interaction, which carries with it important values. One of those values, which is the more we talk and deliberate about things, the more actually we are likely to protect rights in the end.
Okay, so I've got just enough time for each of you to answer a wrap-up question. If you had the chance to go through this all again, what ought we have done and differently? What structures or mechanisms or procedures would you have rather put in place instead of the ones that, quite rightly, and I totally accept the need for quick and immediate decisions, imperfect decisions that they therefore will be. How would you have re-engineered, or what might you try now to retrofit into the future? And given the advice seems to be, well, look, first of all, this is probably not the only time this will happen, and it could take much longer before it completely disappears. If I can throw that at you first, Tom.
In terms of the immediate response, I would have put more effort into keeping Parliament open. That would be my main thing. Parliament is our main body for scrutiny.
So even if it was done by remote
technology, I think that is preferable to not having Parliament sitting at all.
Federal and state?
Federal and state.
Because everyone did the same thing. The first thing that went was, we'll do away with that and let's just try and deal with the problem.
Yeah. The sidelining of Parliament cannot continue. That is absolutely vital to our democratic system.
Adrienne?
I agree with Tom that has been the weakest and the least justifiable part of the response. I think that I would also have wanted to put in more oversight earlier. I think I would want to...
Oversight by whom?
Well, I think that the Senate Committee on COVID-19 should have been an immediate reaction and not something we did after we saw the Kiwis do it and thought what a good idea that was, and there was a bit of pressure. I think that we should and we still need proper oversight of the way that the app is working, bespoke oversight.
Or not working,
or not working, but functioning. Yes, without wanting to take a view on that. But bespoke and tailored to the app. And I think we actually need really to think about what political protest is going to look like in this post-lockdown era and not respond to particular protests as they come up, but actually kind of work out a way in which this can be managed going forward, because we're going to need to do it.
William?
Well, it's very hard to add anything to those, but what I will say, I think, is a broader theme that comes out of both Tom and Adrienne's answers, which I agree with, is the importance of maintaining accountability during times of emergency in compatible with the crisis, with the public health crisis. But and ways of doing that are online parliaments, keeping committees going, into media reporting, and ensuring that media it remains critical of what's happening. And I echo what we've been saying already. I think something like the National Cabinet concerns me because we have seen in Australian history in the past federation itself fundamentally change during times of emergency, and I would be very unhappy to see the National Cabinet itself to become an example of that, where the Commonwealth wanted to basically turn federalism into top-down vertical governance as opposed to what it should be and what it actually has been and has shown really well during the COVID crisis, which is actually a collaborative process of deliberation over really difficult questions of when to open schools, when to reopen borders, and so forth and so on, and keeping, because that's the only way to make really seriously revisable and kind of, I think flexible responses is through accountability.
It's often said that hard cases make for bad law, but at the same time, what we've seen here is that our democratic institutions have been stress tested just as much as our health and medical institutions by an unprecedented crisis. And it's shown us, as we've pretty much agreed, both the best and the worst of the way our system functions. Look, I'm indebted to you all, and particularly to those so many of you who have sent in contributions on Facebook Live. Germs Justice number 3 today has featured Professor Adrienne Stone, Director of the Centre for Comparative Constitutional Studies, Dr. Tom Daly, Assistant Director of the Melbourne School of Government, and Associate Professor William Partlett, Public Law Specialist, and they're all from the Melbourne Law School at the University of Melbourne. And Germs Justice has been brought to you by Big Ideas on Radio National and ABC Radio Melbourne's Facebook studio. I'm John Fain, and thank you so much. I hope you've enjoyed it, and thank you for joining us.